Hi, my name is Dory Goikman. I'm an attorney and certified mediator. I primarily work with clients throughout California, but mostly in the Bay Area. Today, I want to talk to you about what the mediation process looks like. Really, this is what my mediation practice looks like, because the first thing that you need to know is that mediation is not a standardized science. The process can really vary from mediator to mediator. There are different types of mediation. It can vary from jurisdiction to jurisdiction. So my goal here is to give you a general overview, and if you are working with me or if you're planning to work with me, to give you an idea of what mediation will look like. Here are my goals when I look at mediation. I want the parties to engage in a process that is efficient and that is fully voluntary. In describing my specific process here, know that it is all to that end, right? To the end of a voluntary and knowing outcome that's done in the most efficient way possible, in a way that minimizes stress as much as possible, and in a way that saves the parties the most money overall, so they can move on with their lives and not spend years in litigation. That's not to say that the process is not stressful. It can be very upsetting and it can be very difficult, and of course it can be very confronting, but the goal is to do it in the least bad way, and that's what I think mediation is. So here is my process. First thing I do, I always try my best to speak with all the parties ahead of the mediation. So I want the parties to feel comfortable with me as mediator and to make sure that they understand the mediation process before going into mediation. I want them to understand that it's voluntary, that I'm not a judge, that I can't make orders, that I can't help them in the sense that I cannot represent them in mediation. I want them to fully understand this before they commit to mediation. So I've really experimented a lot on the best way to do this, and I can tell you there are other mediators who will either set up a first session as sort of a discovery session, but that's still a paid session between the parties, or they do only joint consultations. Here's the way that I do it right now as of the date I'm recording this video. People usually come to me either by themselves or with another party. So either someone comes and they say, I want mediation, but I'm not sure if my spouse does, or I want mediation and my spouse does too. And I offer either the option of doing a joint consultation, which is my preference, and which I think is appropriate in many cases, or I give the option of doing 2 solo consultations. And I'm kind of walking a fine line here, because in that consultation, in those solo consultations, I cannot offer legal advice, right? Once I do that, I am off the case as mediator. I can't do that. But as mediator, I also can't keep confidentialities in the same way that I can as an attorney. So my first step is this. Even before the consultation, I try to clarify my role in writing as to what can or can't be done in consultation. I want you to feel comfortable, each of you to feel comfortable with me as mediator, but I cannot use these consultations to offer you legal advice. I can only answer questions kind of the kind that I'm talking about in this video. So I can tell you about my process. I can tell you about step 1, step 2, step 3. I can tell you about how we collect financials. I can tell you about whether or not I make recommendations, right? I can answer those types of questions, but I can't tell you, oh yeah, you should file the divorce now, or you should do this, or you should do this. I cannot give that kind of advice in the 2 separate consultations. My goal for these consultations, and this is what I make clear to every client, is to A, answer any questions that you have that I feel I can answer about the mediation process. B, determine if I feel that attorneys should be present in mediation, because there are times when I think there is a sufficient power imbalance that I suggest you really should have attorneys in mediation, or I'm not comfortable mediating this without attorneys. And most importantly, C, making sure that each party, not just one party, is comfortable with me as mediator. Now, once the parties agree to mediate, we need to figure out a way to get their financial information. And part of a divorce in almost every state, and certainly in California, is a financial disclosure. So for me, it works best in mediation if we have all of your financials ahead of the first session, and we spend that first session trying to identify what assets exist, identify any existing agreements as to those assets. So for example, maybe you have a prenuptial agreement, maybe there's a postnuptial agreement. In order to do that identification process in the first session, I need to have the financials. And this is the part that it always surprises me how much it's underestimated. It's challenging going through your own financials. It's challenging going through other people's financials. I need a lot of details. I personally use a software called Family Law Software. I send the parties the link ahead of the session. The parties typically either fill this out together, they fill out a questionnaire together, or they take turns filling out the questionnaire. So each party has a section for their income, the assets that they know of, et cetera, et cetera, et cetera. And then they're able to submit it to me. Once they submit it to me, that's how we know we're ready for the first session. I tell the parties, if you schedule a session, please schedule at least a few days to a week out, assuming that I have that availability, in order to give yourself time to fill out the family law software. Now, I just want to give one caveat about disclosing your financial information. When parties are coming to me in mediation, and I'm cautious when they're not represented by attorneys, you should know that in entry into family law software, maybe it prejudices you somehow. That is not for me to say, right? I have the parties sign agreements that they're going to mediate in good faith, because these are the things that you disclose will ultimately end up on court forms. You should know that those court forms are made under penalty of perjury. And you should also know that there are remedies in California for failing to disclose assets. But that said, I'm not your attorney. So when someone says to me, oh, should I disclose this? Should I disclose this? Should I disclose this? I can't advise you about that, right? If you have those kinds of questions, you need to speak to an attorney. And to be honest, I think it's always a good idea to speak to an attorney before you decide to move forward with mediation, or during the mediation to have someone on your side, even if they're not in the mediation representing you. You need to speak to your attorney as to your disclosure if you have questions about it. So once the financial disclosures are completed through Family Law Software, you will click a button that says Submit to Professional. We will most usually already have a date on the calendar. We come into our mediation session. Usually that session is 2 to 4 hours. In that first session, that's when, like I said, we will identify the various assets and debts. This is where it starts to diverge on a case-by-case basis, because some people may disclose very little, some people may disclose a lot. Sometimes we have to spend the first session coming up with a plan for the rest of the time, right? So we can say, okay, here's 2 pieces of real estate. We need to schedule appraisals. Here's a business. We need to get an expert to value the business, et cetera, et cetera. And then there are other cases where, there's 4 checking accounts and that's it. We can get through it very quickly, and we can talk about how those things are divided. So this is where I really begin to take it case by case. But typically, I deal with the financials and try to come up with a plan for anything that we can't deal with in that first session, as early as possible. And the reason being that things related to, children or things related to support in many ways tie into the financials, and we need to have an understanding of what the financials are going to be so that we can come up with a plan for, let's say, where people are going to live, in order to then make those other decisions, right? This is where sort of the art of mediation comes in, where I use my discretion to very quickly come up with a plan of, okay, let's do this in this order. Do both parties agree? And then sometimes that's not appropriate to do things in that order. So for example, sometimes there's an emergency related to a child custody, and we need to have a temporary plan in place, right? And so maybe we'll mediate that temporary plan. We'll come up with a plan to then put it on another session a week later to talk about something else, right? So sort of the benefit of mediation, yet another benefit over going to court, is we can schedule things out very close to each other, right? You're not waiting months for court dates. We can just schedule things out, and we can talk about things in the way that makes sense for your case. Typically, the way that I do mediation is, we don't sign agreements in session. A lot of times I will send a session summary with our progress and our goals and our to-do list for each party. It really depends on a case-by-case basis and also what the parties want. But typically our goal is to get to a final global settlement of all issues at the end, and that might happen at the end of multiple sessions, not in the first session. Typically not in the first session unless it's a very simple case. Now, again, that's not always the case. Sometimes we may enter into a stipulation even in the very first session that might have to do with temporary support or a temporary custody right away, because maybe there's sort of that level of need among the parties, and it might be a sort of time-sensitive situation where we need something and it needs to be filed with the court. So that's always possible. Now, a lot of these things that I'm talking about are based on the assumptions that the parties are not represented, because honestly, the bulk of my clients are unrepresented parties, or at least parties who have attorneys, but the attorneys are not active in the mediation. They're sort of in the background reviewing agreements, but they're not present in the session. Now, if attorneys are present in the session, it does go a little bit differently. I want the parties to use their attorneys as efficiently as possible, and I want to respect what the attorney's goals are and plans are. So I tend to sort of ask the attorneys, okay, what's the case status? What do you need? What are we mediating? I let them lead a little bit more. With the attorneys, it's more like they need a neutral, and the attorneys are kind of already setting the direction of the case. There may be trial dates or court dates or hearings that are already on, and we're trying to mediate last minute before one of those hearings, right? So when the attorneys are involved, I very much let them lead the process. Now, once we get through that initial session where we're identifying the assets, we get through any emergency issues, we literally go issue by issue, dealing with what applies to your case and coming up with an outline of what a solution looks like. All of my sessions are on Zoom, or for the most part, they're all on Zoom. So I will just literally pop a template of the agreement onto the screen, and I begin to type into it, and usually in the form of an outline, because I want to come up with some, very specific language that I like to sort of think about. Typically, we're just going issue by issue, and I'm helping, and again, particularly where there are no attorneys, I'm helping the parties identify what the issues might be. So for example, let's say there's a buyout. Sometimes the parties don't think about, well, how's that buyout going to be financed? How, what's going to be the time frame? So I try to pose those questions to the parties to make sure that we are dealing with everything that needs to be dealt with. Now, if there are minor children, typically in a divorce, at the very least, you're going to be required to run the child support guidelines. This isn't my requirement. This is a court requirement. So if there are minor children, that's going to be at the very least what you're going to need to do. So using your entry into family law software, we will typically spend some time running the child support guidelines. Many times people want to deviate from those guidelines. That's fine. You have to use specific language. You have to do specific things to do that. But it still needs to be done knowingly, right? And then I want to talk about child custody. Now, child custody is a lot of things. There's legal custody, there's physical custody, there's visitation, and there's roles and responsibilities of the parties. We talk about things as specific as exchanges, holidays, right? So again, this is somewhere where I try my best to provide a lot of guidance, not in the sense of even potential solutions, because I'm listening out to the parties for those to think about their lifestyle and what fits, but I try to help the parties understand, like, okay, let's say you live more than 30 miles apart. We might treat this differently than if you're living next door, right? Let's say the child is an infant. We might treat this differently than if the child is 15 years old. Let's say the child is in activities every day after school and one parent lives further from the activities, right? So I try to approach all of those topics with experience to get you a realistic parenting plan that actually makes sense for your life and isn't just a cookie cutter agreement, right? It actually makes sense, because my feeling is the level of specificity that's required for your parenting plan, it really, really varies. When two people trust each other and parent well together, they need a plan that's much less specific than two parents that really distrust each other and kind of need that all on paper, right? It varies. I mean, sometimes our parenting plan is as basic as a calendar, and, people say, oh, we'll decide the holidays on a case-by-case basis. And we just want to make sure neither party leaves the country with the kids, or, there's like one particular concern, but that's basically it. And sometimes we have a parenting plan where we have rules on when the parties are allowed to ring each other's doorbells, right? Exactly the meeting point for where they're going to meet on exchange days. Every single holiday laid out, the parenting time percentage to a T. Right. So it really, really varies. And again, part of the art of mediation is me sort of assessing what your relationship looks like, the level of trust that you have in each other, and the level of guidance that you need in order to get you a parenting plan that works for you. And to be honest, parenting plans, they can be very touch and go, right? We can come up with something that's beautiful and it might still not work for you. You might need to come back and adjust it. You might want to work later with yourselves to adjust it, right? You might want to come up with a parenting plan on your own and then bring it to me to sort of put it in writing and make any touch-ups and suggestions, right? There's a lot there, and it's your life, right? It's how you live your life on a day-to-day. In assisting me with my parenting plans, I use a software called Custody Exchange. It's also a very commonly used software. You might have heard of it. There are suggested templates there. It helps me calendar things. I can provide you with a calendar all the way until the children reach the age of 18. There's a lot that we can do with Custody Exchange, but I also don't feel locked into it, right? It's kind of a starting point, and it helps me address all the issues that might come up in a way that's pretty systemized, and we just go issue by issue. So typically a parenting plan, and this is in a typical case where there's not something really extraordinary and the parents are willing to come to an agreement, you're looking at maybe 2 to 4 hours working on that plan, and it can be a very intense and emotional session, so you should be prepared for that. But typically after that amount of time, we're able to enter into something, and based on that parenting plan and either the child support guidelines or what the parties want to do, we basically come up with an entire comprehensive plan as to the children, and we talk about under what circumstances we might want to modify that plan. Sometimes we sort of do things automatically based on age. Sometimes we don't, right? So it really depends on what you need, like everything else in mediation, but that's generally what the process looks like. Now, it's possible that there are other issues in your case that I haven't touched upon yet, and those are sort of on a case-by-case basis. My rule for mediation is if one party wants to bring the issue in, we bring it in, right? And that's because one party wants to litigate an issue, they're free to litigate it, right? So my goal is to get you to a settlement on all issues. So now let's say we have an agreement on all issues. Wonderful. What typically happens is I finish sort of drafting the proposed agreement outside of the session. I'll try to email it to the parties, let's say within a week or so, depending on my schedule. I again advise the parties to have that reviewed by an attorney. There's never any pressure when I do mediation to have them sign right then and there. I know that's not always true in all mediation, so please be cautious of that. And that's something to ask your mediator. You know, if you're in another state or you're considering another mediator, talk to them about how signing works, right? And make sure that you're comfortable with, you know, okay, are we going to be expected to kind of make these quick decisions and sign in session, or are we going to be signing outside of session? And like I said, I do signing outside of session. And the sacrifice there is, yeah, maybe I'll end up with fewer settlements, but I would rather have fewer settlements than settlements where someone feels pressured to do something and does something, you know, that later on will have consequences that they're not comfortable with. That's not how I want my practice to go. So that's just the decision that I've made. Now, what happens after the settlement also really depends on what stage of the case you come to me. So some people come to me, they've already filed. The agreement can be filed as a stipulation in their case. You know, there might be unique circumstances surrounding that as to whether, you know, one party needs to file an answer or whatever. I cannot really go there. I can't advise on that. This is like a case-by-case thing. So, you know, kind of don't listen to me on anything that I say here. But when we have a true uncontested case where nothing has been filed, and we just have mediated everything first. So we've come to the settlement agreement first, which in my mind is the ideal scenario. Then either an attorney or even our office assuming that the parties will waive conflicts of interest, can assist you in filing that case. Now, at that point, again, we are walking a very fine ethical line when filing something for you. And that ethical line is, I'm filing it for you, but I'm not filing it for you as your attorney, right? So you have to fill all sorts of forms waiving conflict of interest, understanding that we're not your attorney. We're basically doing this in the form of document prep, translating what you agreed to in the document to the court filing for the purpose of obtaining your divorce. If at any point an argument arises, if at any point a party becomes non-cooperative, I will recuse myself from this and I will not continue with the filing. That's because I cannot be involved in your disputes. Everything is proceeding on the understanding that we have agreed to these terms, we are cooperating, and we are filing an uncontested case, usually proceeding by default. Usually you don't have to even have a hearing on the basis of your mediated settlement agreement. And like I said, because it's a very fine ethical line for me to walk, there might be cases where I say, I'm not doing the filing, I don't feel it's appropriate, the level of conflict is too high, or something has happened. Like, so for example, if you have filed part of the case before you come to me, I'm not going to assist you filing the rest of the case. Even if I'm not serving as the attorney in your case, I still have ethical guidelines as an attorney, And I don't like to get too close to those lines at all. So, again, really on a case by case basis as to whether we can assist you in the filing. But assuming everything is okay, everyone has been truly amicable, there are no disputes, then we can assist you with the filing of your case in the form of document preparation. We can't represent you in any hearing. We cannot represent you as to any issues that arise. And again, if an issue arises, that's it. We will not do the filing. So that's the overall process for divorce mediation. In case I haven't said it enough in this video, it will vary case by case. So take it all with a grain of salt, understanding that this is a very customized process, and that's the benefit of mediating your divorce. If you've already decided to work with me and you're watching this for that reason, to help you sort of prepare for the mediation, I want to thank you for working with me. Of course, I may be biased in this regard, but I think you've made a good choice. If you're thinking about mediating and you're still not sure, I'd be happy to offer a consultation. Just reach out by email below, dori@otrmediation.com. And like I said in the beginning of the video, we can do a solo or joint consultation. Thank you so much for watching.